I am Erik Gerding. I am a capital markets partner here at Freshfields. I just joined in January after spending almost 4 years at the SEC at the Division of Corporation Finance.
And I'm Melissa Hodgman. I spent 17 years in the Division of Enforcement and have joined in December, so I beat Erik by 1 month.
And we are delighted today to have 3 of the last 4 general counsels at the Securities and Exchange Commission with us today. On screen is Bob Stebbins, who is a partner at Wilkie Farr, who was general counsel under Chairman Jay Clayton. We have next chronologically is Dan Berkovitz, who is a general counsel under Gary Gensler. And then the most recent general counsel, Megan Barbero, who is now a partner at Venable. So we are going to talk about where the SEC is in 2025. Why don't we start out with just going around among the 3 general counsels on what your big predictions are for new rulemaking and enforcement priorities for the new SEC leadership. Bob, do you want to offer your views?
Happy to. Can you hear me?
We can.
Okay, great. I guess as to enforcement, I would say back to what it was under Jay, so a focus on the Main Street investor yet again. Obviously, there's not going to be FCPA this time. I would think you're going to see the damages, again, more tethered to past history. I think a little more flexibility to come in. I think the advice we're giving people, there's no point in coming in early on cases, but I think that will change again. So I think those would be the main things for enforcement. As to rulemaking, obviously crypto, that'll be a delicate one. They're going to have to do something. Proxies front of mind. And given they're not going forward with the court case on the environmental release, they're going to have to do something in that regard as well. So I would think those would be the top priorities in my view.
Any disagreement, Dan?
No, I agree with everything Bob said. I think in enforcement, we're going to see more focus on cases where there's investor harm rather than procedural violations where there hasn't been harm, it's just been violations of procedure. So we're going to see a focus on investor harm, on protection of retail investors where there's actually damage to retail investors. Crypto, yes, that's going to be a high priority. There's also going to be focus on expanding, or potentially expanding the access to some of the private markets, the accredited investor threshold, the other thresholds for investing in private funds. I think that will be a combination, again, of SEC and potentially legislative action.
The nice thing about going last and following these 2 astute general counsels is I don't have to add a lot. I think on the enforcement side, just to build out on something Bob said, I think we'll see lower corporate penalties out of concern that that's taking money from shareholders. So I expect we'll see smaller dollar amounts in those cases. And I agree with Dan that there'll be a focus on fraud, fewer negligence, fewer policies and procedures violations. And I agree on the rulemaking side, both in terms of the effort to come up with rulemaking in the crypto space and also walking back. We'll see what happens in the climate litigation, but I think that's one that they'll be considering walking back. There's several other rules in litigation, whether they walk those back or wait to see how litigation plays out, I think remains to be seen.
Anything, Melissa, surprise you from those answers as our resident enforcement attorney?
Nothing surprises me. I would just add a few things. One thing that I think is very interesting is people think enforcement is going away, but Acting Chair Ueda, in almost every speech he gave, even if it wasn't about enforcement, added a paragraph on enforcement. And he talked about 3 things each time that he did this. The first thing was fraud. which was both accounting fraud and disclosure fraud. And in that area, I think it's important to know that with Paul Atkins coming in, the way Paul Atkins thinks about fraud, he sometimes refers to it as criminal. He knows the difference between civil and criminal, but what he's trying to say is the level of misconduct that you need is at an extraordinarily high level. The next topic that Mark would hit was insider trading, and I think that that's something that people need to be thinking about, in particular because the Division of Enforcement as it exists today is extraordinarily good at making connections. They use data and a lot of data analytics in a way that they didn't at the beginning of my career there. It's an extraordinary system that they've put together, and they're scraping social media. They're scraping all sorts of sources of public and then also their own feeds of information, and they can find connections that they didn't find in the past. And they can also identify trading in other types of, whether it's other types of trades, swaps, for example, credit default swaps, complex products. This is an enforcement division that is going to be very focused in that area, and something that I think people need to be thinking about in their policies and procedures right now, and in handling AI and the things that those allow people to do to aggregate information. And then the final area, less interesting probably to most people in this room, is conflicts of interest. So I think that those would be the other areas they go to. And then Paul Atkins, very interested in individual liability. This goes to the penalty point I think you were making, both Bob and Megan. This commission is not going to want to hurt shareholders a second time. They would rather get the deterrent effect of going after individuals. So this is something that people need to be thinking about in terms of protecting their people. You need training. You need to be thinking about policies and procedures, and people need to protect themselves in their decision making.
So a lot of the audience might not be familiar with the exact role that the General Counsel of the SEC plays within the agency. How did you see your role when each of you held that chair, and how have you seen it potentially evolve over time? Why don't we go in reverse order this time, Megan?
Sure. So the General Counsel's office touches essentially everything that the Commission does. It was an office of about 160 people, mostly lawyers, and divided into groups. So there are rulemaking attorneys within the office who review all of the rules coming out of the rule writing divisions. We have enforcement lawyers who review all of the matters that are going up to the Commission for vote. We have an appellate staff of about 30 people because...
You're using the present tense, Megan. We can't do that anymore.
Sorry. It hasn't, for me, it hasn't been that long. So the office has a staff of about 30 people who defend the Commission and all of the rulemaking challenges, and also handle all of the appeals from the enforcement matters. And then their adjudication staff, oversight staff, and the general law staff who handle kind of the bread and butter issues. And as the GC, you have the privilege of seeing all of the difficult legal issues that weren't resolved at a staff level, and then conferring with the chair, commissioners, division leadership. And so it really is a great job in the sense that you get all of the most interesting legal issues that the Commission is grappling with, and that's what comes across your desk.
But sometimes I've heard repeatedly when I was at the Commission that we don't do policy, we're lawyers, but some general counsels have been policy advisors to the chairman. Like, how do individual general counsels navigate whether they're doing policy or legal advice?
Well, and some chairs and their general counsels might disagree about what the role is. So you might have a chair who wants to have more of a policy advisor in a GC. I think a lot of this, and I'll be interested to hear from Bob and Dan, but depends on the relationship between the chair and the general counsel in terms of how the role is defined. At bottom, I think it's a a legal role in terms of legal risk assessments and ensuring that the commission is operating within the bounds of the law, but because much of the work of the commission is policy related, you're almost necessarily weighing in on policy decisions, but coming at them from the legal side.
Yeah, so when you're general counsel of the SEC, you have to go and you're approved by the commission. You don't work for the chair, you're the general counsel for the commission, although the chair is your really supervisor and your direct report. So you have to balance that role between providing objective legal advice to all the commissioners, both the majority and the minority, but you're also working for the chair. So there's a delicate balance there, but you have to be approved by all the commissioners. When I was going around to all the commissioners, I kept hearing, they all said to me, oh, the general counsel, you're the 6th commissioner of the agency. There was this lore at the agency that the general counsel is the 6th commissioner. Well, I got in the job, and rather than like the 6th commissioner, I felt like I'm the 3,571st lawyer in the agency. Like the agency, there's a lot of lawyers. So as general counsel, we have the head of the corporate division, Erik, who's a professor of law in disclosure, right? Erik was, and he has a chief counsel who's been practicing that area for 20 years. We have an enforcement division, the former attorney general from the state of New Jersey, and then we have Melissa, and we have like the team that's been doing enforcement for like 15, 20 years, and we're reviewing their work. So what is the value add of another legal office on top of very highly talented experts in their respective areas? Well, the value is like, why does a general counsel, for example, if enforcement wants to bring an action to the commission, it has to be approved by the general counsel. Why do you do that? Well, your enforcement lawyers, they get involved in cases, they're zealous, they want to prosecute, and you need a more dispassionate maybe level of review where people aren't so invested in that. So we provide that level of review, and I would say probably about 95% of the enforcement cases, what I would call would be not controversial in OGC, and maybe the fewer ones. Okay, we have a legal theory here, like an insider trading. We've never brought this type of insider trading before. Fits exactly within the definition, but here's the factual situation, but it hasn't occurred before. What are the litigation risks? And we provide an additional set of eyes, similar with rulemakings. We have our office, the former office that we had worked for, defends the rules in court. There's an appellate division within the Office of General Counsel. I think it's probably the best appellate division outside the Solicitor General's office in the federal government, at least one of them. And they're in federal court that has an docket of about 30 cases at any one time. In Court of Appeals, how does that rulemaking look? How will that look to the Court of Appeals? How can we structure the rule to defend it the best way in the Court of Appeals? And that's something that like a lawyer in Corp Fin might not necessarily have experience. And then we can advise the commission on that. Here's the litigation risk of writing the rule this way or doing the rule that way. We get the comments in from the public on a rule. You can't do that. You don't have the authority. Well, are they right? Or are they wrong? And we have the expertise to look at it from that angle. Plus, the other function is really ensuring that rules are coordinated between the various divisions. If Corp Fin, for example, is working on a particular rule, making sure that investment management is also aware of the rule and can comment on it internally. So it does have, I felt like in many instances I'm as much a traffic cop as it is as a practicing lawyer in that office, ensuring everybody who should be looking at it is looking at it from all these
For the
various
record,
perspectives.
again, we did get along very well with investment management.
Oh, good.
You know, once they understood like who was the division that had a little bit more expertise.
You mean enforcement?
Anyway. But Bob, how did you see your role? I mean, when you advised Chairman Clayton, were you a policy advisor in addition to sort of the legal advisor and traffic cop?
I probably had a little bit of a unique role in that Jay and I have been best friends.
Lost your audio.
Can't hear me?
Yep, now we can.
Okay, so Jay and I have been best friends for 35 years. He was the best man at my wedding. So have a kind of unique relationship. So I was pretty involved in everything that went on in the building. And actually, well, we'll leave it at that. But I think, I think the summary that everyone gave is great. I think the role changes a little bit depending on how involved the chair wants OGC to be and how much risk the chair is willing to take on some of the positions the commission is taking. Jay didn't really want to lose in court. Other chairs are more willing to do that. So anyway, but the role is a great role. It's, as Megan said, you see everything. It's one of the great jobs in the federal government. It was a thrill to do it.
So you talked a little bit about appeals court litigation. Regardless of how the presidential election turned out, there was a series of Supreme Court and appeals court decisions that pretty radically transformed the environment for the SEC. Let's start with one of them, the Corner Post case, which changed the way in which the statute of limitations runs for challenging agency rules under notice and comment rulemaking, challenges under the APA. How has that case changed the calculus for the agency in terms of being able to defend rules? Who wants to take that?
I can start, or you want to start?
Go ahead.
So the Corner Post case was essentially the Supreme Court said that the 6-year statute of limitations under the APA would run from the time that the injury occurred and not the time the rulemaking had been adopted by an agency. And it was important because in Corner Post, the plaintiff there had been formed, a decade after the rule had been adopted. And so all of a sudden they were newly injured and they could challenge a rule that had been sort of long-standing, a long-established rule. In terms of how it's changed things for the SEC, I think there's not a lot that the agency can do about the fact that, many of the agency's rules are decades old. We're now in a situation where you could have a newly formed entity that could then, be injured by the fact that they are now regulated, not because the rule is new, but because they are new. And they could bring a facial challenge to rules that are decades old. And that's significant because admin law has changed so much in the intervening time, and the way the agency approaches rulemaking now is very different. The way the courts approach review of rules is very different. So you might take a rule that's 30 or 40 years old, and it may not contain the same economic analysis, the same sort of rigor in terms of statutory authority and the rest. So I think there's certainly a potential threat to longstanding rules. It remains to be seen kind of how all of that plays out in court.
Yeah, I would agree with what Megan said, and Corner Post certainly raises the potential that people could create injury sometime down the road. If they want to challenge a regulation, you create some association or something like that, and you say, well, we weren't around when the regulation was passed, and so it could permit that is one fear. On the other hand,
that's actually what some people said happened in Corner Post, right? I mean, create an association in a particular state, get Fifth Circuit, make it in the Fifth Circuit, and there you go with your challenge.
Exactly. And on the other hand, you have statutes and you have regulations applied in particular circumstances years afterwards, and you can still challenge the application of that to you, although you can't. Previously, you couldn't do the facial challenge, but people were able to challenge its particular application in a particular factual circumstance. So the concept of something old being challenged later on in some circumstance isn't radical, but certainly the facial challenge and vitiating the rule entirely, this opens that up.
So
Yeah, I would just say I
another
think it's
case.
very.
Go ahead, Bob.
It's a potentially a very difficult decision for the commission, and I actually think it has the potential to be the biggest deal of any of the things you're about to talk about. I agree with Dan that I don't think the Chevron deference is really such a big deal given the way things have been run there, and I don't think that jarcossy is such a big deal given since 2017 how the administrative courts have been run. But I do think this has the potential to be a very big deal.
Yeah, and I'll just add before we go on, the enforcement division and some of the things that I've heard since I've left was concerned that there would be more accusations of rulemaking by enforcement, that this would set up a situation where if you couldn't have rules, if you couldn't establish things that would be enforced, that it was going to be common law, it was going to be case law, it was going to be examinations, it would be that sort of an approach to things, and that would be the sort of thing that people would be facing, that the commission and other agencies would, under this opinion, start using more enforcement in order to establish the principles and make sure that you could have predictability and know which way things were headed. I don't know if that's what we'll end up with, but that is a possible, unintended consequence of the decision.
All right, let's move on to like the greatest parade of hits. So Bob mentioned the Jarchese case, in which limits the ability of the commission to bring civil actions for fraud in front of the commission's own. I feel like you're going to judge me here.
Well, I'm about to interject and say it's not just the ALJs, it's any administrative proceedings, including in front of the commission, but go ahead, please.
So you got to go to federal court for a whole bunch of civil actions and fraud cases and maybe more.
If you want to litigate them. So the settlements are still going forward with waiver language in front of the commission. But what the commission can't do is bring an enforcement action before the commission in a fraud case where they're seeking civil money penalties. I mean, that is clearly out of bounds following the Jarchese decision.
Is that going to limit the enforcement division's ability to bring cases? Now we got to go to a federal district court.
I think that it's not going to change things aside from 102Es and failure to supervise, things that could only be brought. Causing, for example, is something that can only be brought in an administrative proceeding. In a district court, you have to prove aiding and abetting, which is a much higher, much more difficult standard. So I actually think that this is something that has been happening, as Bob said, since 2017. There have been many fewer litigated ALJ actions. They were kind of limited to 102Es and things like that. But how this happens going forward, I don't know that it's going to change much.
And it may be worth noting the SEC is differently situated from a lot of federal agencies because the SEC enforcement has statutory authority to choose between the administrative proceedings in front of the agency and going to district court. There are lots of other agencies where Congress set up schemes where the only avenue for seeking civil money penalties is in front of the agency, and so they don't have the same opportunity to pursue the case in district court.
I've had experience both at the SEC and also the prior agency I worked for, which is the Commodity Futures Trading Commission, which for unrelated reasons basically got rid of its ALJs a decade ago. And for the last almost 20 years now, any type of civil penalty case, they've only been pursuing in federal court. And frankly, it hasn't affected them a bit. Now they have not quite as large docket as the SEC, but the enforcement divisions bringing cases in civil court rather than the ALJ has not hurt the CFTC. When we're talking about like the administrative cases, the licensing cases, the disbarring people cases, things like that, those are still appropriate. And I'm not sure that they're affected by jarcossy. It's under the Seventh Amendment rationale. Some of that will have to play out, obviously, but for the big things like a fraud suit with a civil penalty, frankly, it's been my experience working for two federal agencies that the agency adjudicative process isn't really that great for those things to begin with. I don't see the agency as harmed by having to go in front of a jury trial to bring a major civil penalty case. I mean, he's still bringing a major civil penalty case before a jury. And the fact that somebody gets a jury trial for that doesn't defend my sense of justice.
So Bob already said that he agrees with you, Dan, that the end of Chevron deference is probably not going to be a big deal for the SEC. Can you explain like your view that you've already written about? Right. So I looked at as Loper Bright, the case was going through the Supreme Court. I looked back at the question of how many times the SEC has gotten deference. So if you got rid of Chevron deference, you know, how many cases might have been decided otherwise? And really basically almost none. I mean, Chevron deference in any major case involving the SEC is almost non-existent. To the extent it exists, and I don't want to denigrate any particular plaintiff or not, but it's in what I would call more minor cases, not the big rulemaking cases. And it almost seems, if you look at those cases, that the courts give deference where they agree with the agency and don't give deference where they don't agree. So you'll find very reasonable results, correct statutory interpretations, and the courts will say, oh, and we're giving deference to the agency. But in a major rulemaking, you don't find many cases where the SEC has been explicitly granted Chevron deference. The courts have actually been pretty harsh, I think, on the SEC. There's been a lot of cases where the courts have not agreed with the SEC on statutory interpretation over the last 20 to 30 years, even prior to Chevron. And they said, we find SEC's interpretation to be unreasonable, not grounded in law, in excess of statutory jurisdiction, the APA standards, arbitrary and capricious, you didn't do the cost benefit correctly. There's a whole parade of these cases throughout. Sometimes the SEC wins, sometimes it doesn't. So I think if you look at the record on the SEC, I'll be coming out with a longer article on this shortly, that there's really Chevron deference hasn't really existed for the SEC. The courts, ever since the beginning of the securities laws, when the securities laws were passed in the 30s, these cases immediately went up to the Supreme Court on the SEC's authority. You had the Howey test in the 40s. You had always, what is a security? What is a security has essentially been judicially defined. It hasn't been done by agency rulemaking. All these cases through private litigation, through enforcement actions, the courts have made tremendous amount of SEC law, so they're comfortable interpreting the statute. They're comfortable saying what the law is. And a lot of the judges don't feel they have to defer to the SEC. And when Chevron came along, didn't really change anything in that regard. There's been a whole body of case law where the courts had been the major interpreters of the securities laws. Bob, do you think you said that the quarter post case you think is the biggest deal. Any other big threats to the agency's rulemaking authority that you've noticed in the last 5-10 years?
I don't think so. Nothing comes to mind. Megan's going to correct me, but nothing's coming to mind.
So do you all think that were the administration to change in 4 years, that an agency, given this particular set of Supreme Court opinions, given this particular judicial landscape, do you think that the agency could return to fairly robust, ambitious rulemaking, or are they going to face a pretty different judicial level of scrutiny?
I mean, I think there's no question. We don't even have to look forward, right? We can look, we're talking about several decisions from the last couple of years. The judicial landscape has absolutely changed in terms of sort of broadly speaking, and I agree with Dan's analysis on the Chevron doctrine, but broadly speaking, agencies are facing increased skepticism. There are, additional hurdles that agencies need to jump over. I think we're in a world now where an agency is going to be looking for much more express statutory authorization a clear congressional statement that the agency engage in rulemaking with very, explicit instruction about how to do so. And one of the challenges for the SEC is that many of the statutory provisions are 90 years old, and Congress didn't write statutes with that kind of express direction then. So it will be harder going forward for agencies to chart a path to successful rulemaking given the judicial landscape, and some of it will be litigation risk assessments. So like, how well received is this rule going to be? How likely is it going to be challenged? And I think that'll be a big part of it moving forward.
I think one important factor in that is process. Okay, I think, and I'm actually optimistic on this given the current composition of the SEC and Paul Atkins becoming chair, who's been there before, knows how the process worked, and he's talked about this in his testimony. I think if you respect the rulemaking process, you do things as the Administrative Procedure Act says. You put out things for notice and comment. You take comments. You respond to comments. If you follow the process and you arrive at a result that's within your authority, I think that lends to stability and certainly increases your chances that what you do will last. Now, if you adopt, interpretations that have a lot of litigation risk, maybe not. But if you say we're going back to basics, we're going to do things, and Acting Chair Ueda actually had this in a speech. We're going to do pre-rulemaking roundtables. We're going to solicit opinion, and then we're going to propose rules, and then we're going to give lengthy comment periods or robust comment periods, and then we'll make a decision. So you really go through this robust notice and comment period. That greatly reduces your chance of getting reversed on appeal. The first thing presented with a hard case the courts will look at is like, what's the process you went through? And if you do a shortcut on the process, you're really increasing your chances of overturning on appeal. So if you go back to basics, you follow the process, I think that will lend to not taking excessive litigation risk and that it'll be overturned.
Can we bottom line this, though, for companies and the general counsels in the audience? If there are going to be pretty severe limitations on the agency's rulemaking, does that lessen the risk of kind of being whipsawed from this particular commission leadership to, let's say, a Democratic leadership in 4 years?
When you say limitations on rulemaking, you mean by judicial or by the executive?
Both.
Okay. Well, first, I don't think any of the decisions that we've talked about, even Loper-Bright, or we haven't mentioned it, but the major questions doctrine, those are questions of how the court interprets, who interprets, how the court interprets. But a court can interpret expansively just as it can interpret narrowly. So Loper-Bright, taking the authority, who you look for to interpret the law, whether you look to the administrative agency under Chevron where it's ambiguous, or you just say, no, the courts are the final arbiter, that doesn't tell you whether the law is going to be expansive or not. The courts can be expansive just as they can be restrictive. Right now, you have several courts, like the Fifth Circuit, that is restrictive. But going back, everything is, we've seen nothing new under the sun. Chevron, which gave the agencies discretion, really was to take out all this liberal DC Circuit decisions that were expanding the law. So Chevron was actually meant to be restrictive. And then, of course, now you have the agencies being expansive, so they want it back to the courts to be restrictive. So this goes around and around, and neither branch is necessarily one way or the other. It depends on the prevailing philosophy in the executive branch or the prevailing philosophy in the court. Now, if it remains to be seen with the new executive orders, the relationship between the president and the agency and the degree of independence and who's going to make the interpretations, whether it's going to be controlled through OMB process or the agency will have some of its traditional, I don't know how that's going to end up yet.
Well, and I think that last point actually really matters for this question of the pendulum swinging back and forth and how much certainty will there be about where the SEC rules land. in part because we're talking not just about promulgating new rules, but also like unringing the bell. And so if the agency goes, without notice and comment to undo some of the prior rulemakings, and those are upheld, in other words, like they could unring the bell and skip the whole process that Dan talked about earlier, I think that will increase the risk that when you have an administration change, you'll undo quickly prior rulemakings and you'll get more of a back and forth. So this is still very early stages, and I think any attempts to rescind rules without notice and comment will be challenged, but the outcome of those cases will also help determine like how much we're going to see the agency's position change. And I think one thing we've all observed this week is the financial markets do best when there's predictability and certainty, and that's a reason that the independent agencies were set up with some independence from the political winds in the first place. And so the more erosion we see of that, the less predictability we see, I think that will be felt in the financial markets.
So one of the big ways that independent agencies are potentially being rethought by this administration is the firing of minority commissioners at the FTC and at the National Credit Union administration. Do we think that the Supreme Court is going to overrule Humphrey's executor? Is this sort of the end of traditional minority commissioners, dissenting views in agencies? And if so, what's the impact long term?
I mean, I'm happy to start, or we can give Bob a chance to weigh in.
Well, so let me address the practical. I'll leave it to my colleagues to address like Humphrey's executor, the dynamics on that. But let me just address the practical, because before I was general counsel at the SEC, I was a commissioner at the CFTC, a minority commissioner at the CFTC. So let me tell you, I see the value of the job that I had, the value of a minority commissioner. I'm very proud of the fact, and actually it was true at the SEC when we were there too, the collegiality on the commission, that we had 5 commissioners who really worked together. There was a give and take. People didn't agree a lot. There was a lot of disagreement, but it was respectful disagreement, and there was a give and take. Every chairman that I have either observed in my career, worked for, worked with, been a colleague with on any of these commissions, has always tried to build a consensus. People don't like to ram things 3-2. They try to build a consensus. And why do you try to build a consensus? First of all, the appellate courts look to the dissents when the rules are challenged, and a lot of dissenting views get incorporated into appellate opinions. On the other hand, a 5-0 rule, even a 4-1 rule, you really, really minimize your litigation risks if you can get everybody on board. The other value of getting other minority commissioners on board is it signals to the other party, the other side, whether it's for pro-industry or progressive or this or that, it signals the commissioner who's carrying who's presumably aligned with those interests is saying, hey, this is okay. This rule's okay. It's not worth challenging. And when they issue a dissent, that's when they're signaling this one is worth challenging. So to the extent that within the agency, you minimize those instances where there's disagreements, you minimize the signaling that goes on to the opposition, you're creating this stability. I was very proud of the fact I was at the CFTC when we did the Dodd-Frank rules. We had 85% of the Dodd-Frank rules that the CFTC did under Chair Gensler at the time had at least one minority commissioner. There was a lot of angst over the Dodd-Frank rules, but in the end, 85% of those rules had at least one minority commissioner on it. And the industry invested in the rules, and they stayed. And Dodd-Frank, Title VII, has been implemented and is law, and I think it's worked. But you had a process of give and take, and there was disagreement. There was hot disagreement. You had a process of give and take. It held up in the courts, and the industry invested, and it hasn't been overturned. Now, if you don't have that, if you just have one-party rule, and you don't have this moderation where people make compromises to get the other party on board, you don't have any signaling going on, everything that the majority does is going to be suspect, then when the pendulum swings and you have another election, someone says, oh, I didn't like the way they did that. I didn't like the way they did that. Let's undo this, let's undo that. And it can go the other way. So I think it's the current system we have where we have these minority commissioners actually promotes this type of stability that is best in the long run, and it minimizes those swings on the pendulums. That's the real value of having minority commissioners. And I think the SEC and the CFTC, the agencies that I've served on and with, they have very well served that function.
So let's sort of go around the room quickly with one major prediction and surprising prediction for what the SEC will do under Chairman Atkins. Bob, you are our resident Republican General Counsel. Let's start with you.
I would say that, I don't know how surprising it is, but just to address one of the things raised, I don't think there's any chance that they're going to, given the proxy litigation, that they're going to get rid of rules without going through notice and comment rulemaking and having a new economic analysis. They are going to do that. I think they will do that on the environmental rule, but they're not going to run a process where they're just going to overturn a rule without going through the entire record again, as Dan was talking about. That's the only way to really do it properly and to safeguard what you're doing. So I would look to that process. I don't think there's any chance they're just going to try to ram it through without going through notice and comment rulemaking and unwind things that way.
Megan, quick prediction? Make it juicy for the audience.
Make it juicy.
Yeah.
Oh, well, I guess then I'll just to make it a little adversarial, I'll be interested, Bob, to see what they do with respect to the executive order that directed agencies in the next 60 days to identify rules that should be undone with a good cause exception to notice and comment, because they've now been instructed by the White House to find a set of rules that are not in the public interest and wipe those rules off the books. And I hope, actually, very much hope that Bob is correct, that the SEC will say that's a null set, and we are going to go through notice and comment rulemaking for any changes we want to make. But I'm not sure what agency leadership does in the face of that kind of directive from the White House to come up with a list of rules to undo without notice and comment rulemaking.
Well, I disclaim that I have no inside knowledge on this, but I believe that they will find a way in the crypto legislation or regulation to maintain the Howey test while providing some type of alternative trading regime for crypto assets that may fall in that test.
I 100% agree with that. I think this commission is going to be focused on materiality and redefining it. I think they're going to do it through guidance, and I think that that's going to allow them to leave in place rules like the cybersecurity rule and things like that, because the definition of materiality changes its application completely.
Well, I will end on guidance. There's been a lot of guidance in the first several months of this administration. It's been pretty impressive just how much this administration has acted for guidance. When some people on the stage, wouldn't let somebody else on the stage issue all the guidance that he or she wanted to. So just saying. There's a different set of rules in effect on guidance. Well, thank you to our panelists. Thank you, Bob, for joining us. Thank you, Dan, Megan, for a really great session. And thank you, obviously, to my enforcement colleague, Melissa.
Thank you for being our proctor.
Thank you.